Okay, so even though the Facebook lawsuits settled and we didn't get access to a lot of information, there were some interesting things that got leaked. Now, a lot of people think this got leaked by Eduardo and his team. We don't really know. So what I want to go over here is an email that Mark sent to his lawyer. I'm going to go over that email, and then I'm going to ask you to think about how should we respond as the attorney. Okay? So this is literally an email from Mark Zuckerberg to his attorney. Okay? He starts off by saying this email should probably be attorney-client privileged. Not quite how to do that, though. Not quite, I guess, sure how to do that, though. So obviously, he doesn't even understand that there's nothing to do to create attorney-client privilege, that it exists for communications between an attorney and their client. So whatever. So anyways, Sean Parker and I have agreed that a price of 1/2 cent per share is the way to go for now. We think we can maybe almost justify, and if not, we'll just deal with it later. That price, what is the value of a share of stock, is an issue related to equity compensation. So let's just put that aside. We'll come back to it when we get to talent in a couple weeks. But if you're really curious, if a company grants you stock, you have to pay taxes. It's just like if the company gives you a watch, if the company gives you a car, if the company gives you cash, anything a company gives you in exchange for you doing work for them is taxable. Well, how much tax do you have to pay? Well, what is the value of the thing they gave you, right? So if a company gives you 1,000 shares of stock, well, you have to pay tax on that. Well, how much tax? Well, what is 1,000 shares of stock in the company worth? Well, here there's a whole cottage industry of people who will do valuations. I mean, if you've done a recent financing where someone bought stock in the company at a certain price, that's a great way to prove how much it's worth. But okay, so let's go off this tangent. We'll come back to that later when we deal with talent. Okay. The next paragraph. We also agree that if the company bonusing us the amount we need for the shares plus tax is a good solution to the problem of us all being completely broke. Okay, so this is very common. So when a company wants to give stock to its employees, and those employees then have to pay tax on the stock, if the employees are broke, how are they going to pay tax, right? So let's say I give you $10,000 worth of stock in the company. You work at Facebook. I'm giving you $10,000 worth of stock. Well, the IRS wants their 25% of that. So you need to come up with $2,500 to pay the IRS the tax on the $10,000 worth of stock you were given. Well, you have a problem because that stock you were given, you can't liquidate it. It's not publicly traded. You're not allowed to sell it to anyone. So yeah, you were given this $10,000 worth of stock, but there's nothing you can do with it. And so if you're broke, if you're some 20-year-old or whatever, you have no money, how are you going to pay the IRS the $2,500 that they owe you? So what companies usually do is when they grant you stock, they also, in conjunction with that, grant you an amount of cash that when you pay the tax, so now when they give you cash, do you have to pay tax on that cash? Yes, right? So if I give you 10,000 shares of stock and I give you $4,000 in cash, okay, that's what I'm giving you because most startups can't pay people what they're worth. They only pay about half of what they're worth. So if you're an engineer, a computer programmer, and you can work at Microsoft for $150,000 a year, if you go to Facebook as a startup, they could probably only pay you $75,000 a year. But the reason why you take that $75,000 is because you get the stock in the company, which you think might be worth a lot more in the future. Okay. So let's go back. So I'm paying you $75,000 a year, but I'm also going to pay you 10,000 shares, and I'm going to give you $4,000 in cash to pay for the tax that you owe on that stock. Okay, well, the $4,000 is also income to you, so you have to pay your 25% tax on that $4,000. So I give you $4,000, 25% you have to pay tax on that $4,000. So you're left with $3,000. Then I give you $10,000 worth of stock, and you have to pay 25% of that. So then you have to pay $2,500 tax on the stock. So I gave you $10,000 worth of stock, and I gave you $4,000 of cash. You end up having to take $3,500 of the $4,000 I gave you and pay all that to Trump for the taxes. The taxes that you have to pay on the cash itself and on the value of the stock. Okay, so that's what this paragraph is discussing. Okay, now this is what we really want to talk about. As far as Eduardo goes, I think it's safe to ask for his permission to make the grants, the granting of extra equity to Sean Parker, Peter Thiel, etc., especially if we do it in conjunction with raising money. It's probably even okay to say how many shares we're adding to the pool. It's probably less the employee stock option pool. It's probably less okay to tell him who's getting the shares, just because he might have an adverse reaction initially. Well, would you say from that movie clip we just watched a few minutes ago that he had an adverse reaction? I would say he had an adverse reaction. Okay, so Mark does not want to tell Eduardo who is getting more shares. Okay, I think we may even be able to make him understand that. Okay, is there a way to do this without making it painfully apparent to him that he's being diluted to 10%, right? So we want to tell him something without actually telling him. You see what the client wants you to do? Remember in module 1 where I had those fake emails from Sheldon Cooper and I told you clients are demanding and clients don't have reasonable expectations, and you're like, no, that's not true. Here's an example of a real life email from a real client asking a lawyer to say, can we tell them but not tell them at the same time? Okay. All right. Okay. That's all for now. I'll send you the list of grants I need made in another email in a second. So that's a list of employees and other people that they want to give stock to. Okay. Sean can send you the grants for his people. Now remember, Mark was in charge of the technology people. Sean was in charge of the marketing, business, sales people, right? That's kind of Mark and Sean divided up the business, because Sean was doing what Eduardo was supposed to do, which is marketing, sales, business development, financing, all that kind of stuff, all of which Mark didn't want to have anything to do with. Mark just wanted to do the technology. He just wanted to make a cool website that lots of people liked. Okay. Sean can send you grants for his people when he stops coughing up his lungs, which I guess is a reference to either being sick or drunk or something. I hope you guys both feel better, Mark. Okay, so now how do we respond to this as the attorney? What do we need to tell the client? So this is where you get into this uncomfortable situation where it's, do I tell the client what they want to hear? Do I tell the client what they need to hear? You will be better served in the long run. You may lose some business, and I've lost business myself by telling clients what they need to hear, not what they want to hear. Because they'll be able to go find some other attorney and tell them what they want to hear. But you will be better off in the long run if you tell a client what they need to hear. So what do we think Mark needs to hear in this case? Well, what comes to my mind is, look, Eduardo's going to find out what happens at some point. So it's better to nip it in the bud and deal with it now, tell him the whole truth. And if there's a dispute, if he gets upset, if he gets angry, let's deal with it now rather than making the problem worse by misleading him in some way. That's only going to make it worse, right? The cover-up adds on top of the crime, okay? So let's read what the attorney actually responded here. Okay, so this is the attorney's response. I spent some time discussing the risks associated with making these grants and picking the per share price of common stock. Mark, you and I should discuss these at length to ensure that you understand them. I've outlined them below for your easy reference. Basically, if a company is granting you 10,000 shares and they're like, hey, it's to your advantage if we make those shares seem really little in value, right? They're only worth a penny. So 10,000 shares, they're only worth a penny. That's $100. You pay $2 in tax or $20 in tax. Well, a risk of that is if the IRS finds out you misleadingly lowered the value of the stock so that you could avoid paying tax, do you think you're in good shape or bad shape? You're in bad shape, right? So that's why there's this whole cottage industry of third parties out there that will help you come in and give you a defensible valuation of your stock when you grant it to an employee so that they can pay taxes on it. Okay, let's put that aside. Okay, so the next paragraph is the one that we really want to think about. So the broad categories of legal risk are fiduciary duty. So first of all, I find that sentence hilarious. The lawyer starts off by saying the broad categories of legal risk are, and then he only lists, or she only lists one, fiduciary duty. Okay? As Eduardo is the only shareholder being diluted, now remember that was the deposition question where Eduardo's lawyer said, well, how much was Mark diluted? None. And how much was Dustin diluted? None. And how much was Sean diluted? None. And how much was this other person diluted? And how much were you diluted? To 0.003%, right? So the lawyer is saying here, look, Eduardo is the only person being diluted by the new issuance of stock. There's a substantial risk that he may claim the issuances, especially the ones to Dustin and Mark, but also to Sean, are a breach of fiduciary duty later on, if not now. I believe that you previously disclosed these future dilutive issuances to Eduardo before the LLC merger. This is what I recommended at the time. Nevertheless, it would be great if there is some way you could obtain a shareholder consent from Eduardo approving these new issuances. It isn't required that the attorney puts an asterisk, but it would be very advantageous and would go a long way towards preventing any future claims he might have for breach of fiduciary duty. I mentioned this to Sean, and he was going to give it some thought. Okay, so fiduciary duties cannot be waived by contract. So even if Mark is right that Eduardo signed a document saying majority can issue new stock and majority can give the new stock to whoever they want, majority can do this, majority can do that, even if the documents say that, there is a fiduciary duty that exists in the default law that cannot be waived, which says no owner of a business can do something that specifically disadvantages another co-owner. Okay? This is why the lawyer is saying, look, the issuance of new shares, especially to Dustin and Mark, violate fiduciary duty. Maybe Sean, maybe not. Why? If Mark made a decision to issue a whole bunch of new stock to everyone except himself and Eduardo, then when Eduardo says, look, Mark, you made a decision that punished me, Mark would say, look, no, the decision I made punished us both equally. I didn't target you. I didn't treat you worse. I didn't breach my duty to you because I treated us both the same. But when Mark intentionally issues a whole bunch of new stock, keeps himself a majority owner of the business, only dilutes himself a little bit from like 65 to 50%, whatever, but dilutes Eduardo from 30% to 0.03%, then that's a clear mistreatment of Eduardo. That clearly mistreated Eduardo differently, treated him differently than everyone else, which is why the attorney is saying that could be argued by Eduardo as a breach of fiduciary duty. And if you go back and rewatch the clip during that scene where Eduardo's attorney is saying, and how much was this person diluted? None. And how much was that person diluted? None. And how much were you diluted? And once he says 0.033%, she looks, go back and rewatch the scene, she looks at the other lawyer and she just takes her pen and goes, and she like smirks at him because she knows that she's got him. Because that fact alone proves that what Mark did by issuing all this new stock and diluting Eduardo but not diluting anyone else was a breach of fiduciary duty.